My name is Carol McGrew. This will be Unit 4, Hearing for the We the People National Finals. In a moment, I will have the judges introduce themselves, followed by the students, and then we will begin the hearing. Students will deliver a 4-minute prepared statement, followed by 8 minutes of judges' questions. My microphone will be muted during the hearing, and I will be holding up the 1 minute and the time is up signs. I suggest using gallery view rather than speaker view. And at the conclusion of the hearing, judges will give brief feedback to teams, and then we will conclude. All right, the judges will now introduce themselves.
All right, good afternoon, everybody. We're really happy to have you here today, and congratulations on making it to nationals. My name is Robert Dyan. I teach American government at the University of Evansville.
My bad. Hello, everyone. My name is Zach Eastburn. I am a commercial litigator in Madison, Wisconsin.
My name is Tom Tinder, and I'm an attorney in Charleston, West Virginia.
My name is Aaron Robidoux, and I'm a council person of our local NHS chapter.
My name is Daniel Manning, and I play on our high school's varsity tennis team.
My name is Christopher Manuel, and I am a section leader in my marching band.
And my name is Rihanna Peterson, and I am the concert master of our high school's orchestra. And our coaches are Miss Lindblom and Miss Litzenberger.
Terrific. Well, I'm going to read the question to you, and today for Unit 4, we're asking question number 1 about the pardon power. And I'll read it to you, and then I'm eager to hear what you have to say. It begins as follows, quote, "It would be inconsistent with the constitutional separation of the executive and legislative powers to let the prerogative be exercised by the latter," close quote. What were the framers' reasons for giving the president the pardon power, and do you agree or disagree with them? According to the framer James Wilson, if the president abuses the pardon power, he can be impeached and prosecuted. Do you agree with Wilson, and why or why not? In your opinion, what constitutes high crimes and misdemeanors? You may begin.
Math has limits. People have limits. Power should have limits. In this same way, we believe that the pardon power should have some limits when exercised by the executive.
The pardon had long been established to executive authorities, including the king, and executives under colonial charters. After the Revolution, state constitutions placed limits on this executive power, often including approval from state assemblies.
During the Constitutional Convention, Colonel Mason argued against granting the Senate any pardoning authority because the body has already too much power and could use pardons as a political tool. In Federalist 74, Hamilton argued against granting the power to the legislature, explaining that deliberation might rouse more tension in times of insurrection and that a single man would be most ready to attend the force of those motives.
So, the founders felt it necessary to grant the power to the president in Article 2, Section 2, Clause 1, to grant reprieves and pardons for offenses against the United States, except in cases of impeachment.
We agree that the pardon power should be an executive power, as it creates efficiency and allows for expedient action. Even so, limitations are required to protect against potential abuse.
Edmund Randolph explained the pardon power should be limited in cases of treason to prohibit the president from plotting treason and pardoning co-conspirators. In response, James Wilson proposed that the check on pardon abuse was impeachment.
We agree that abuse of the pardon power in cases of treason is a high crime and thus an impeachable offense. However, impeachment is a drastic measure for lesser abuses.
Instead of impeachment, we propose legislative review, like the 1974 amendment proposed by the late Senator Walter Mondale. Congress was given the power to overrule pardons by a 2/3 vote within 180 days of the pardon. The power would remain in the hands of the executive, but it would be checked by the legislative.
So, President Ford's pardon of President Nixon or President Clinton's pardon of his half-brother could have been overruled by the legislature. Once in effect, legislative review instead of approval would dissuade abuse and controversial action, maintain the rule of law, and focus the pardon power on granting reprieves for unjust guilt.
Article 2, Section 4 of the Constitution reserves impeachment for conviction of treason, bribery, or other high crimes and misdemeanors. Though the phrase high crimes and misdemeanors seems vague today, it was not nearly as obtuse when the Constitution was drafted.
The 17th and 18th century legal use of the word high referred to someone under oath who acquired special powers and duties not held by the common person. Erwin Chemerinsky argues that it doesn't have to be a crime. It's about a serious abuse of power. In this way, an abuse of power, that is a high crime, is a political offense or misdeed committed by public officials against the state.
Consider the articles of impeachment drawn up against Andrew Johnson for his violation of the Tenure of Office Act. The articles argued his crimes were unmindful of the high duties of his office and of his oath of office. He abused his power.
Additionally, consider the articles of impeachment against federal judge Robert Woodrow Archibald in 1912 for accepting bribes and corruption. The House Judiciary Committee stated that the intricacy of the crimes indicates a well-defined plan to use his official position and influence as a member of such court for financial gain. He abused his power.
Thus, high crimes and misdemeanors is defined as an abuse of power by elected officials against the state.
At the Virginia Ratifying Convention in 1788, George Mason argued that the president ought not to have the power of pardoning because he may frequently pardon crimes which were advised by himself. It may happen at some future day that he will establish a monarchy and destroy the republic.
While we disagree with the extremity of Mason's statement, we agree with its sentiment. Limits keep power in check. Limits keep tyranny underfoot. The pardon power cannot be limitless in the hands of a single person.
Okay, I like the clarity of your presentation, and you took a stance there, and I'd like to follow up if I may. You have this notion of legislative review that you think would be an improvement. How do you make that happen, and what are the realistic prospects for that?
Yes, so the process by which our legislative review would occur is through a concurrent resolution. That is, it would have to be proposed by any member, but both in the Senate and in the House. Then it could be voted on to attain that 2/3 majority.
And all of
My question is, how do we get there? I mean, how does that become the new status quo?
In order to enact this legislative review, it has to go through the Article 5 amendment process because according to the Constitution, the pardon power is unchecked and given to the president. So it would have to go through the amendment process in order to actually be part of the Constitution.
Do you sense that there's widespread support that you'd get 38 states to ratify such a move, or that even the Congress as it's currently constituted would jump at the chance to listen to your good counsel?
I think
Yeah, Rihanna.
I think that after the many controversial pardons that happened during Trump's administration, that we could get a lot of support for this. One example of a controversial pardon that recently happened was that of Roger Stone, who was part of the Ukraine investigation occurring with President Trump, where about the election that recently happened. And so because he was part of the questioning process, he shouldn't have been able to be pardoned, but yet he was.
We've seen a history of these amendments being proposed in Congress after a particularly abusive presidential pardon. For example, Mondale originally introduced his amendment after Ford's pardon of Nixon. Then in 2001, the amendment was reintroduced after many abusive pardons. And then even in 2019, after Rihanna referred to the pardon of Roger Stone, H.J. Res 8 was introduced that would keep the president from pardoning himself, family members, or anyone that he pays, any of his employees.
As Danny said, these pardon limits are continually reintroduced, and I think it's actually unlikely that the amendment would be actually accepted because the last amendment to actually be added to the Constitution was in 1992, and because of this length of time, it would be unlikely. I think the amendment is important and should be instated, but I do not think that it would be likely to actually be part of the Constitution.
So it sounds like all of you are in favor of this legislative review amendment, and maybe I'm wrong in that. Maybe there is disagreement on that. But if you are, what are the downfalls of legislative review?
I think one of the downfalls, if in a hypothetical situation, is that our review would constitute a 2/3 majority, but just so happens that if one party becomes more than a 2/3 majority, which is probably not likely to happen, but even if this does happen, this legislative review would basically be destroyed because it would give way to partisanship in Congress.
You gave a couple examples of abuse of power in the impeachment process. Give me 2 or 3 more, please, and explain them.
I think one abuse of power, though it was not in the impeachment process, this president should have been impeached. In particular, Andrew Jackson. For example, he, after the Supreme Court ruling of Worcester v. Georgia in 1932, they said that the U.S. could not infringe on Cherokee lands, but he publicly stated that he would not carry out the Supreme Court order and that he went against it, ultimately setting up the Trail of Tears that will happen years later.
Another abuse of power that I think was Trump's first impeachment. He did use his own first power and abused it for his own political gain. And in doing so, that is an abuse of power and thus an impeachable offense.
Another example of abuse during the impeachment process can be seen during Clinton's impeachment. He was impeached for the reason of lying under oath, which is just to show that it was clearly very partisan because every president has lied at some point throughout their office to the American people.
Thank you.
One of the things that you see when you read about the original discussion of the pardon power is that it could be used during time of rebellion or insurrection. And some could argue that we're living through such a time, that we saw that this year. Do you think this is an apt moment to use the presidential pardon power, or what might your thoughts be on that?
We can see that the founders validly concerned the pardon power in cases of insurrection, as seen because George Washington used the pardon power after quelling the Whiskey Rebellion to pardon 2 leaders of the Whiskey Rebellion and restore calm to that area.
Additionally, I would also say that a pardon in this hyper-partisan and rebellious time, as he stated, would be essential, though it may not be publicly upheld, as in Gerald Ford's pardon of Nixon. Before he was able to be impeached, he was pardoned by Ford before any impeachable offense could be against him, in that his reasoning was in order to quell the nation, as Washington did from the Watergate scandal.
You guys might have been the first group to mention the impeachment of a federal judge. And I think you cited maybe one of the only examples that exists. Why do you think that judges aren't impeached more?
I believe that judges aren't impeached as much because they have to go and use the Constitution to uphold why they're making decisions that they do. And whereas for the president, they have the power of executive orders where they can overstep the first 3 articles of the Constitution, where it sets up a set of checks and balances. And thus, it's much more that people will disagree with their actions because they're able to overstep those checks. And so then the impeachment process can go forth.
Similar to the vague wording in Article 2, Section 2 of high crimes and misdemeanors, judges are also in office only in times of good behavior. And this vague wording has actually made a more limited standard of impeachment for judges, as we see with only 16 articles of impeachment being submitted for judges, federal judges in the U.S.
The founders, in setting up the impeachment process, did involve the judiciary by having the Chief Justice serve as the arbitrator, so to speak, at Congress's or at the Senate hearing. Why do you think that they included the judiciary in that small part? And why didn't they have the judiciary more involved in the impeachment process?
The reason they didn't have the judicial branch be super involved is because they believed that the judicial branch was necessary to be the second line of defense. So after the impeachment had happened, the president can still be tried for those crimes. And so if the judicial branch was part of the impeachment process, then it'd pretty much be set in stone about how their court hearing would go after.
Thank you.
All right, thanks very much, everyone. Great job. These are all such exceptional teams, and you're really attacking this juicy question with gusto. I wrote down on my notes, clear as a bell. Your presentation was clear as a bell. Some of the crisp statements that you made, I had to write them down word for word because they were just so to the point. even the first thing you said, math has limits. I mean, you caught everybody's attention. So that's a great way to jump in. You took a position on a proposed reform that I thought was sensible, that could work if it were adopted. And realistically, it might not be adopted, but as you said correctly, we don't amend the Constitution very often, even if it needs it. But a good public purpose could be served by having the discussion. And so Mondale's idea keeps coming up again and again, and that's all to the good. It advances our understanding of the way the process works. So I'll leave it at that. I liked your use of examples, but everybody at the national level comes equipped with examples. But as my partner said, we heard some examples from you that we haven't heard so far today. So hats off to you.
Thank you.
Just to echo that, I mean, I also wrote down crisp and punchy. You guys started with this math has limits thing, and as a lawyer, these types of these hooks that you guys put in here. I mean, someone here is in English or a grammarian. Someone really knows what they're doing with that. It's very apparent. You guys had these repetitive refrains throughout it. He abused his powers. It's very clear. The way that you delivered it, also the cadence was very strong. Also, the way that you worked with each other, when one of you was giving an answer, you were engaged with each other, nodding. That was very noticeable, very effective and powerful. So from a syntactical sort of brass tacks point of view, excellent work. From a substantive point of view, I also, again, just you had examples that I really appreciated. And this legislative review Mondale thing, hadn't come up before. That's why I think a lot of us were focusing on that. So it was nice to have a nice discussion on that. I love that you brought up impeachment of federal judges. And when I asked a question on it, you provided information that I didn't even know. And that was, good to hear. You really found a way to bring in knowledge that you had to a question that maybe was a little bit one that maybe you weren't expecting. So all around good work on that. You did stake a clear position in the beginning. One thing that I would like to, maybe see more of would be just some reasoned disagreement amongst each other on certain issues, if you can. I know it's hard, again, if everyone disagrees on something or agrees or disagrees on something, but to foster a critically dispassionate conversation on an issue where someone says, I agree with this, well, I disagree with my colleague, all that kind of stuff, because it helps to bring out all the different sides of things. But really a very well presented opening statement and question. Thank you so much.
Thank you.
I just follow up quickly on that specific point that Zach made. Even if you all have the same opinion on a thing, give us the other side. And I guess because Zach and I are lawyers, that's what we're taught to do. You got to know the other side, where they're going to come from, what their arguments are going to be, and so forth. So even if you don't agree with it, it's very helpful to say, now, we think this way. Now we understand that the other side or they're another position on this, and state that, because I say to you that you've done a ton of research. I mean, and you all have a particular, it seemed like you all had a particular area of expertise that you had sort of focused in on. And when the question came up in this area, this person was going to respond to it. And if it was in another area, someone else was going to respond to it. And one other thing I'd say to you is the quotes that you used in your opening presentation. Quotes are great and quotes are important, but quotes are useless if they don't tie in to what your position is or what the topic is or whatever. And all of your quotes were right on point. Just did a very good job with that. Let me just say that you showed us, or you told us at the beginning, that you're already leaders with the particular areas of responsibility, leadership responsibility that you have in your school. And we just want to, and then you demonstrated your leadership by making a wonderful presentation to us today. Please don't make this be a semester topic or a a class that you had to take or whatever, please stay involved and use your leadership skills in the future, because Arizona needs you and the country needs you. Congratulations to you. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.